The agreement provides that the Attorney General and Riverkeeper shall file a joint motion with the NRC to withdraw their contentions and shall, and I quote, use their best efforts to cause other potential parties, interveners, and interested government entities in the NRC proceedings to join or not oppose withdrawal, end of quote. Who are these potential parties? Has this happened? Could it jeopardize the agreement if such parties did not join the motion or if they oppose the withdrawal?
By the way, I want to amend earlier testimony, Senator Murphy, because you asked me who else was involved in the negotiations.
Yeah.
So the Attorney General was also involved in the negotiations. So
there's 4.
yeah, so forgive me, all right? This was all part of the settlement agreement, and so I do not believe that there are any parties that are going to stand in the way of the settlement agreement.
But are there other parties that existed that needed to be brought in to the conversation at any point? Because I'm just curious about the mention of other parties specifically in the agreement.
No, not that I'm aware of.
Not that you're aware. Okay. The agreement doesn't say much about decommissioning. It's one paragraph. What exactly is your understanding of the commitment vis-a-vis the agreement between the state and Riverkeeper and Entergy?
With respect to decommissioning?
Yes.
If I understand your question, there's no agreement between Riverkeeper and Entergy with respect to decommissioning.
So in the agreement, it says, in that short paragraph, it says, within 120 days after, and they're referring to Entergy, has made a reasonable determination that the funds in the Nuclear Decommissioning Trust are adequate to complete radiological decommissioning and any remaining spent nuclear fuel management activities. So it's basically saying Entergy shall make appropriate filings after they determine that there's reasonable funds to complete radiological decommissioning. So that's the essence. I'm just, refreshing your memory.
Right.
In March 16th, 2016, NYSERDA, which you're chair of, filed a statement or filed in a proceeding that in rulemaking that the NRC is currently undergoing, although I'm not sure what the status of that. But in March, there was a statement issued from NYSERDA and from the Attorney General's office, and on, again, NRC's regulatory improvements for decommissioning power reactors. And the state argued that the NRC should eliminate the 60-year delayed decommissioning option and that all decommissioning should be completed in 10 years. NYSERDA further argued that decon is the best option that protects state and local resources. Did this come up in the agreement conversations, in the negotiation?
It came up, but again, this is an issue. That's why NYSERDA has provided these comments to the NRC. The issue of the decommissioning process, the termination of the trust fund, all these various things are really a subject for the NRC, and you have a representative here from the NRC who can explore this in greater detail. So this was an area where it was not a long part of the negotiation, but we discussed the possibility of an earlier physical decommissioning, And instead, I think what we were able to negotiate was, to Senator Croce's concern, we were able to negotiate a immediate beginning of transfer of waste into dry cask storage, because without the agreement, the waste would continue to accumulate in those pools, and nothing would have been moved into dry cask storage until after the plant would have shut down.
So presumably leaving resources, because they could be a waiver applied to the NRC, to use some money for dry caskets. So you're saying that, this way the money is going to be essentially used for radiological cleanup other than spent fuel, which was another argument that was made in your testimony to the NRC, that would be appropriate. I'm putting words in your mouth, but that's, So just to remind you about the testimony, I realize it was a year ago, that, New York further argued that decommissioning trust funds should not be used for spent fuel management or any other non-commissioning expense, going to your point about dry caskets. New York further argued that decommissioning expenses should be limited to activities that reduce radiological contamination at the site. New York further argued that sites such as Indian Point, specifically mentioned, with subsurface contamination may cost more than the formula that the NRC uses. New York further argued that there should be a complete energy preparedness plan in place during decommissioning. New York further argued that there should be a requirement for an independent audit of all relevant trust funds aligned with, I'm quoting, aligned with realistic decommissioning planning, including site restoration costs for subsurface contamination. I'm wondering if any of those topics came up in the negotiation.
No, they did not. And again, I'd ask you to raise some of these issues with Entergy. I don't want to speak on their behalf, but I think one of the points of contention that we've had in over the years with Entergy is the issue of what are state authorities versus federal authorities, and I think Entergy has taken the position that they have not wanted to. They have had a very strong legal perspective that the federal government has certain responsibilities, and they have not wanted to concede certain state authorities out of concern about setting precedent.
So in the, in a filing that Entergy made with the NRC, it said that to decommission Indian Point 3, it would be $1.1 billion, which is about 400,000. They're short about 400,000 currently. Was it discussed whether or not that would be adequate for decon versus Safe Store, or was it assumed that, because of the amount of money in the trust funds, that Safe Store was the only option, which means that they would have up to 60 years to make that land usable for local concerns?
So again, in terms of decommissioning the trust fund, the adequacy of the trust fund, that is in the realm of the NRC.
So could it have come up? I mean, clearly this is a legal document. It's an agreement between the two parties, and it was discussed somewhat, at least the option of decon versus Safe Store. Was there a reluctance on the part of Entergy to engage in those conversations? I mean, you implied that by saying that the compromise was, or that the agreement speaks to the dry casket, or moving the spent fuel rods into the dry caskets. Knowing the community's need to use that land, I just wondered to what degree, that was part of the conversation, and whether it can still be part of the conversation, or, we've lost that opportunity. Whether, I guess, Vermont, as you know, was very active in trying to promote a quicker decommissioning. Entergy owns that plant, and, initially it was scheduled for the same 60 years, and most recently, they sold it, and the decommissioning is going to be taking place, I believe, in 10. So I just wondered, is the state going to be involved? If you feel you gave up negotiating it into the agreement, is there going to be involvement on the part of the state to help the locals drive Entergy to a decon solution?
We are certainly going to continue to work with the communities and with Entergy to try to ensure that the decommissioning of the plant happens as soon as it can practicably.
So in hearings held in Vermont regarding the decommissioning of Vermont Yankee, it was clear that Entergy and the NRC had a difference of opinion about who would be responsible for additional costs beyond the 60-year safe store period. Entergy argued that they have no responsibility past that time. The NRC argued that Entergy should continue to be responsible. I'm going to ask the NRC, what enforcement power they have, but was this a concern? Going to Senator Croce's point about liability, there's clear, in the New York testimony, liability was discussed. I think it was in the Attorney General's comments, not in NYSERDA's, but liability was a concern over, because of the length of time. There could be bankruptcy, the business could go, could sell it to somewhere else, which may not be as reputable or what have you. So, if, is there, could we have addressed the liability issues in the agreement? And I'm curious as to why we didn't.
Well, of course, this is all very hypothetical and might be quite a long period of time in the future. There are these existing approaches to decommissioning and decommissioning fund. I've already talked about this several times. If you're concerned about the future financial viability of Entergy, any representation that would have been in a contract wouldn't have had any particular value. It was not something that was not. We felt that the existing arrangements and with the NRC and the operators and the role of the federal government provided sufficient protection for the state.
So we have a few more years left, with Entergy operating Indian Point. Was there any, or is there any conversation going on about increasing that trust fund? Where does the money come from? Could we do that in order to guarantee that we could go with a different option? Could there be any negotiation in there, so that the $724 million currently in IP3, could be increased to the point where we could at least decommission part of the property earlier? Was there because if we are assuming safe store, which is what they were assuming when they made the filing to the NRC, and we don't even have enough money for that, then we clearly don't have enough money for decon, because the difference between decon and safe store, as we know, is a financial decision. It's not a, although we can be clearer when we talk to the NRC, but it doesn't seem to be more than, at least New York argued in their testimony, doesn't seem to be more than a financial option or difference. So is there a possibility of increasing the trust fund to the point where we can decommission Indian Point earlier?
Well, I believe that people from Entergy will tell you that as the plant operates, there are additional contributions that are given to the decommissioning fund. But again, I want to stress yet again that Entergy has made certain decisions with respect to being in the merchant business, has had concerns about the ongoing economics at the plant. So this was a negotiation. There was after 10 years, there was a moment where both sides had an interest in negotiating, have a negotiating settlement. So Entergy was not prepared to increase the amount of money that it was going to commit to the decommissioning trust fund. I believe that they will say that, and the NRC will say that the funds over time will be adequate to decommission the plant.